Welcome to those who join us here in the Banco Court in Brisbane and to those who join us from different parts of the world. My name is Peter Applegarth. I'm a judge of the Supreme Court of Queensland. I acknowledge the presence of the Chief Justice of Queensland, the Honourable Catherine Holmes AC, and other judicial colleagues who are present here in person tonight. I also acknowledge the distinguished scholars and jurists who join us online, and that in Australasia at least, we are meeting one way or another and in many places on the lands of those traditional owners and custodians. I especially welcome our friends and colleagues from the Greater Sydney area who are in lockdown. Although Brisbane's not in lockdown, I remind all present in the courthouse, except for those speaking, that you have to wear masks for the duration of this lecture when and while in the building. And unfortunately, the COVID restrictions mean that we can't provide the food and refreshments here after the lecture as we'd planned. This event's been made possible by the combined efforts of the Australian Academy of Law and the Supreme Court Library, Queensland. The Honourable Alan Robertson, Senior Counsel, who's President of the Australian Academy of Law, very much regrets that COVID restrictions prevent him from travelling from Sydney to Queensland for this evening's lecture. He's asked me to say the following about the Australian Academy of Law. It was established in 2007. It's independent and comprises some 380 elected individuals of exceptional distinction in the discipline of law who are committed to the advancement of that discipline and to justice according to law. Fellows are elected by the Academy from the legal profession, from legal academia and from the judiciary. The Academy provides a bridge between each of those sections of the community, or the legal community. The Academy's objects are pursued through public conferences and seminars like this, prizes and scholarships in its publications and newsletters. The Academy gratefully acknowledges the valuable support for this event by the Supreme Court Library Queensland, and this lecture forms part of the 2021 Selden Society Australian Chapter lecture series. Alan's asked me to draw your attention to some forthcoming Academy events which will be accessible remotely. Further details on the Academy's website. On the 8th of September, the Academy has organised an event to mark the 40th anniversary of the commencement of the General Anti-Avoidance provision of Part 4A of the Income Tax Assessment Act. Our Federal Court colleagues no doubt will mark the occasion. And former Chief Justice of Australia, Murray Gleeson, will be one of the panellists. On the 7th of October, there's the annual joint seminar with the Australian Academy of Science, and there were two eminent scientists and two eminent lawyers giving their perspectives on artificial intelligence. On the 21st of October, there's the 10th annual Patrons Address that will be given by the Chief Justice of the Federal Court, James Allsop, AO, who I'm very pleased joins us tonight online. And finally, there'll be a seminar here in Brisbane on the 3rd of November 2021, at which heads of Australians' intermediate courts of appeal and other heads of jurisdiction will discuss common issues about the operation of intermediate courts of appeal, and that promises to be a unique and interesting occasion. To tonight's lecture, which, as I said, forms part of the Selden Society's lecture series, may I thank Justice Bradley, Chair of the Library's Legal Heritage Subcommittee, along with Catherine Graff and Megan Reeve from the Supreme Court Library for all they've done to make this event possible. The Library engages in public education in many ways, and that includes advancing understanding of our legal system and legal heritage. Tonight's talks are about a turning point in Australian law and the jurist who wrote a dissenting judgment that shines like a beacon, at least to observant lawyers and historians, almost 100 years later. On a Saturday afternoon in 1937, Mrs. Chester's 7-year-old boy, Maxie, drowned in a water-filled trench that a careless council had left unfenced. Mrs. Chester, her husband and neighbours spent hours searching in vain for the lost child. Eventually, she witnessed his lifeless body being recovered from the trench. She suffered what the law then called nervous shock, but today might be described as post-traumatic stress disorder. Max was described as a particularly brilliant boy who seemed to be the hope of the family. Only one judge on the High Court thought that the law gave Mrs Chester a remedy. Justice Evatt's dissenting judgment is a masterpiece of legal scholarship and writing. It truly marks a critical moment in our law and its approach to psychological trauma. Tonight we'll hear from Gideon Haigh about Justice Evatt's background, time on the High Court, and his dissent in Chester and the Waverley Corporation. Associate Professor Kylie Burns will then speak about the contemporary relevance of Chester's case to the law's response to psychological trauma. Gideon Haigh's new book, The Brilliant Boy and the Great Australian Dissent, recovers H.V. Evatt, Doc Evatt, as one of our nation's most interesting and dynamic public figures in law, in politics and in culture. It also explores the turbulent and toxic relationships between members of the High Court in the 1930s, along with the ghostwriting achievements of Sir Owen Dixon for one less productive judge. In the 1920s and the 1930s, jurists throughout the common law world were grappling with how the law should respond to what was then styled nervous shock cases, how to contain otherwise indeterminate liability to passers-by, and not allow claims by people who lacked what was described as normal fortitude and who were treated as especially vulnerable to psychological injury. As Associate Professor Burns will explain, the law still grapples with these issues. The Chief Justice of New South Wales in the 1930s, Sir Frederick Jordan, is rightly revered as a great jurist. However, Evatt's dissent in Chester's case dismantled Jordan's dismissal of Golda Chester's claim. In an earlier case in 1936, Sir Frederick Jordan addressed how standards had changed about the foreseeability of shock to, quote, a normal human being, unquote. He remarked, spectacles, which would have been viewed with equanimity by our stronger stomached ancestors of the 18th century, who took pleasure in viewing public executions and public floggings, would cause great horror in these softer times, or at any rate, in the community in which we now live. Chester's case illuminates how judges in the 1930s, and Justice Evatt in particular, viewed individuals' vulnerability to negligently caused psychological injury. In his distinguished career, Gideon Haigh has published more than 40 books and contributed to more than 100 newspapers and magazines. His international preeminence as a cricket writer tends to eclipse his work as a writer on business, medicine, true crime and history. And he also somehow managed to find time to teach remedial English to judges at judgment writing courses. His latest book would make any professor of law or history very proud. The book confirms Professor Geoffrey Blaney's description of Gideon Haigh as one of Australia's most versatile and skilled historians. We sincerely thank Gideon for travelling to Queensland to speak to us in person, and that requires him to undergo a COVID test and isolate when he returns to his beloved Melbourne. So he has truly made a real sacrifice in coming to us in person here tonight rather than zooming in. Would you please welcome Gideon Haigh?
Thank you, Peter. Yes, it is great to be here tonight to enjoy my 18 hours interstate. It feels like I'm sort of a paratrooper who's been dropped behind enemy lines just very briefly. So I'm enjoying all the exotic sights of Brisbane. I just walked past the Grosvenor Hotel, which advertises cold beer and hot girls. We don't have those in Melbourne. Saturday, 14 August 1937, in Sydney, dawned clear but damp, it having rained heavily for the 2 preceding days. People emerged from their homes, kids returned to the streets. Among them were the Chester children, 15-year-old Benny, 12-year-old Rose and 7-year-old Maxie, who'd settled in Waverley's Allen's Parade a fortnight earlier. Later that afternoon, only the older 2 came back. Although we don't know exactly how they separated, it is hardly difficult to imagine. Benny and Rose wanted to go to the pictures rather than look after their kid brother. But by the time the Star Theatre emptied, Maxie's mother Golda was anxious, an anxiety that worsened when a neighbourhood search proved fruitless. If you've studied torts, you know exactly what happened next. As darkness closed in, searchers concentrated their efforts on a ditch at one end of the street abandoned by council workers during the week's rain, now brimming with water. Children had been observed jumping from side to side during the day. So it was that at about 6:30, police fished the limp, muddy figure of Maxie to the surface. Resuscitation efforts failed, the boy had drowned, the mother suffered a nervous collapse. Not long after, the law moved in. Under the Antique Compensation for Relatives Act, the family had no cause of action. A solicitor, Abe Lander, mounted a case instead for nervous shock. 80 years later, in The Brilliant Boy, along I came to try and make sense of their efforts, in particular those of H.V. Evatt. I can trace the genealogy of The Brilliant Boy quite precisely. For the last 15 years, I've been involved with judicial colleges in Australia in judgment writing seminars, 1 or 2 a year, mingling professional writers with judges and other judicial officers. Peter Applegarth is one of my star pupils. The idea is that judgments are literary as well as legal exercises, and that those who craft them benefit from time to time from reminding of the tenets of good English expression for the purposes of clearer thinking and more accessible reasoning. One day at one of these seminars, about 3 or 4 years ago, the discussion turned to the intersection of the law and literature, and mention was made of Chester versus the Council of the Municipality of Waverley. Among the judges, everyone knew it. Me, a journalist, I did not. But I had an abiding interest in Evatt. I'd read the 4 biographies of him while remaining unsatisfied by them. They'd not told me much more than that Evatt had been a judge before he was a politician. There was something missing in everything I read, which is what had made Evatt such an attractive personality in the first place. There must, I had this nagging feeling, be more to him than Sir Robert Menzies' punching bag. When I read this dissent in Chester, that mystery was suddenly dispelled. It was a first-rate piece of writing and reasoning, way ahead of the dismissive judgments of his colleagues. It was moving and erudite. It was terse and astringent. It invoked British justice, but was prepared to push on, even if it meant Australian courts going alone. I understood why Geoffrey Robertson has described it as an example of Evatt's profound belief that humanitarian principles could be deployed by judges to develop a common law that would meet the needs and challenges of a changing world. It contained a flavour of the man, or at least the man Evatt wished to be, striving through his countrymen's conservatism and indifference to nurture a bigger, fairer culture out of a mixture of high ideals and deep personal ambition. Chester then offered an opportunity to look at Evatt afresh. For Evatt in 1939 was a man of seemingly unstoppable momentum. There's a wonderful vignette in the diary of the writer Nettie Palmer. 8 years on the bench and still only 44, Evatt had just returned from a year abroad where he'd surveyed the world scene, pursued his fascination with modern art, written a book, lectured at Harvard and Columbia, and fraternised with the likes of Franklin Roosevelt and Felix Frankfurter. The man leaves you with a sense of the fullness of life, wrote Palmer. It's partly physical, the broad, powerful shoulders of a former footballer, the gusty voice and laugh, but partly his management of energy and time. Ever since, at that fabulously early age, under 40 it must have been, he accepted an appointment to the High Court bench, he has taken for granted that, in this Olympian calm, he can do what he wants. That was the man just about to write the dissent in Chester, which reflects both his powerful commitment to justice and his brooding dissatisfaction with the bench, culminating a year later in his entry to federal politics. More than that, I think, salient aspects of Evatt's biography resonate with the tragedy that befell Golda Chester. Evatt was one of 8 boys. from rural Maitland, 2 of whom died in infancy. His father died when he was 6. Mother Jessie was fiercely ambitious for young Bert and supportive of his intellectual precocity. His secondary and tertiary educations were a pageant of honours. He was one of only 170 barristers in New South Wales when he joined the bar. He was only the university's 3rd Doctor of Law. Like most Australians of their generation, the Evatts were also visited by wartime tragedy. Jessie patriotically saw 2 teenage sons, Ray and Frank, off to war. Neither returned. Jessie never recovered from the loss. And Evatt suffered, I suspect, a species of what we would now call survivor's guilt. Thrice turned down for military service on grounds of poor eyesight, he lived with a sense of having failed to save his brothers. A man who loses both parents and 4 of his 7 brothers by his mid-20s can be pardoned an acute sense of mortality. In Evatt, then, I think we see the interplay of a strong sense of destiny and a highly developed dread of the external forces that might thwart its fulfilment. Often deeply suspicious of adults too, Evatt was entirely disarmed by the young, solicitous of their welfare and sentimental of their innocence. Having suffered fibroids, Mary Alice, his wife, was unable to bear her own children, so the couple raised an adopted son and daughter with an almost obsessive protectiveness. You can see where I'm headed here. The strong maternal bond, the consciousness of mortality, the sense of children's preciousness, and the drive to make a mark. If you wanted a sympathetic judge to extend the law in the case of an accidental death of a child, Evatt J is whom you'd choose, right? One other thing. In the Supreme Court, as Peter mentioned, the Chester's family doctor testified that Golda's loss was magnified by the feeling that this boy was a particularly brilliant boy and seemed to be the hope of her family, as she told me. A particularly brilliant boy in his own family, Evatt would surely have understood that mantle. After all, why was Evatt there in the first place? Evatt remains the High Court's youngest appointment, a 36-year-old legal prodigy with extensive experience in workers' compensation, where he and his younger brother Clive were frequently briefed by the aforementioned Abe Lander. Labor caucus's promotion of Evatt and Edward McTiernan, slightly older and likewise left-leaning, was unmistakably designed to balance the court more congenially to the trade union movement. Mind you, had you wished to create a dysfunctional High Court in the 1930s, you could hardly have done better. The 2 Chief Justices, elderly Duffy and emollient Latham, were unequal to harmonising the outsiders with their proud, priggish, mistrustful colleagues, Owen Dixon, Hayden Stark and George Rich. Evatt gave a number of influential judgments in his decades on the bench. He affirmed trial by jury in Mercer versus the Commissioner for Road Transport and Tramways. He clarified Australia's external affairs power in the King versus Burgess, ex parte Henry. He provided Australia's first liability standard for negligence in Australian Knitting Mills versus Grant. He adumbrated a tort for privacy in Victoria Park Raceway versus Recreation Grounds Company Limited versus Taylor. He defined freedom of political speech in the King versus Hush, ex parte Devaney. Most renownedly, he was the judge who defended the right of the anti-fascist writer Egon Kisch to remain in Australia when the government strove repeatedly to deport him. It seems that he virtually wrote Kisch's case in the King versus Carter ex parte Kisch for his counsel. From his extraordinarily retentive memory, Evatt often drew a line from Milton: "Let truth and falsehood grapple, whoever knew truth to be put to worse in an open encounter." It informed, for better and worse, his later resistance of the Menzies government in Australian Communist Party versus the Commonwealth and during the Petrov affair. The irony is that it was not Evatt's tendency to dissent that caused friction on the bench so much as his tendency to agree, at least with Dixon, who also strongly influenced Rich and McTiernan. The imperious Stark sneeringly referred to them as the parrots, not perhaps without reason, using computational software to detect echoes of Dixon in the writing of others. The researchers of Ghosts from the High Court's Past in the University of New South Wales Law Journal in 2003 concluded that Dixon at least contributed to almost a fifth of the judgments of the notoriously indolent Rich. Dixon's diaries further confirm that he not only dictated Rich's judgment in Chester, but in a concurrent negligence case, Ruby Corbin versus the Commissioner of Railways of New South Wales. Corbin and Chester, I think, deserve to be treated as a pair. They came on a week apart. Both are appeals from the full court of the Supreme Court of the full bench of the Supreme Court of New South Wales. Both involve a mother seeking compensation for the accidental death of a son. In both lower court hearings, the plaintiffs were represented by Evatt's younger brother Clive. Both were given cursory treatment by the lower court judges and by Evatt's High Court colleagues. Evatt's dissent in the unreported Corbin, therefore, reads like a rehearsal of the themes and the tone which so distinguish Evatt's dissent in Chester. Sidney Corbin was a 17-year-old clerk. On 9 July 1936, he boarded the 5:43 Bankstown train at Museum Station. About 200 metres from his stop at Banksia, he adjourned to the vestibule. Rather than slow, the train accelerated into a 35-degree curve, lurching violently. Despite holding a stanchion 18 inches from the open doorway, Corbin was hurled to his death. There had been a rush of such fatalities, thanks to the custom of New South Wales suburban trains travelling with open doors, which they would for another 20 years. But the full bench of the Supreme Court quashed a jury's award of damages to the family, Chief Justice Jordan pinning the blame on Corbin's own carelessness. Everyone knows that the passage along the rails of a swiftly moving vehicle involves a considerable amount not only of vibration, but of movements which may variously be described as jolting, lurching or swaying of varying degrees of intensity according to speed, grade and direction. Stark and Rich breezily agreed when it got to the High Court. Anticipating he would be in the minority, Evatt held nothing back. Following on his earlier conclusion in Mercer, he first decries judges invading the province of the jury and studies closely the evidence the other judges had barely considered, including that the rails on the curve had recently been reported as out of position, that the engineer was unable to prove that they had been repaired, and that the driver claimed not to have noticed the accident and to have destroyed relevant records. Evatt stresses the uncontradicted testimony from two witnesses that Corbin had been holding tightly onto the stanchion in the doorway. One said that the youth had been sent flying out of the train, the other that it was as though someone had pushed him. He draws the solid inference that the jolt must have been a very substantial one if it broke the grip of a young and very athletic man. He deplores again and again the very dangerous practice of travelling with wide and open doors, turning on its head Jordan's point that everyone knows about the jolting and lurching of trains. As Evatt said, if knowledge of the above facts may be imputed to the travelling public, it may equally be imputed to the responsible officers of the government railways. There are two other anticipations of Chester. Evatt draws on precedents from two legal heroes, Lord Atkin and Benjamin Cardozo. He finishes by explaining that despite knowing that the appeal will fail, he has elaborated his reasons because the case is of great importance to the travelling public. And one hears the echo of this in the opening lines of Chester. This is a case of considerable general importance. It concerns a rule of the common law of England, and the principles involved will greatly affect the development of the law of negligence. Evatt would have realised at once in Chester that he was in the minority. Dixon's diary informs us that Latham, Stark and Rich made up their minds instantly on the case. The High Court took its cues in Chester from the joint judgment of the full bench of Chief Justice Jordan. What caused the plaintiff any physical injury which she may have in fact sustained was the shock of learning some hours after the event, and perhaps thereafter brooding upon, the fact that her child had been killed in an accident. It is true that the information which caused her shock was imparted to her by her own visual perception and not told by something told to her. It is true also that she learned the effect of the child's death at the spot at which the accident had occurred some time previously, but she was there not in the character of a wayfarer startled by a distressing sight, but of a person looking for the body of a child then believed to be dead. Jordan, as Peter pointed out before, was out of all sympathy with the nervous Nellies of nervous shock, and Latham, Stark and Rich all found for the counsel with a similar note of gruffness. Latham urged that death was an everyday occurrence, its effect on others usually transient. Stark maintained that the council was bound only to consider reasonable probabilities, normal persons, and the ordinary range of human experience. Rich/Dixon considered that the council's responsibilities extended as far as looking after the roads, and since Golder was neither using the road nor an eyewitness, her shock was not reasonably in the council's contemplation. Everything about Evatt's judgment in Chester is a dissent, even its length. At 14,000 words, it is 6 times as long as the average judgment of the 1930s. As in Corbin, Evatt begins by laying out events. He introduces Maxie, a boy of 7 years. He introduces the trench, its crude railing, and the irresistible combination of sand and water that brought the children in the neighbourhood to play at the side of the pool. He specifies the trench's dimensions to accentuate the contrast with the children. Thus, the depth of water in the trench was, for the most part, in excess of the height of the small children playing there. In this way, the menace of death was very great and very near. Then, something remarkable. In the Supreme Court, Golder had, in her poor English, struggled to express her confusion and horror. Evatt now sought to enter her mind to understand the nervous shock of her agitated search and horrifying discovery. The plaintiff had resided in Allen's Parade for only 14 days and at first was unaware of the special menace of the deep trench. As a result, it did not occur to her or her fellow searchers for some time that the child might have fallen into the trench. Late in the afternoon, however, it was suggested by someone that Maxie, the plaintiff's child, might have fallen in the water. Coming with her husband to the side of the trench, the plaintiff was at once beset with fear at the sinister significance of the trench, especially when one of the searchers was unable to plumb the depth of its water. The plaintiff was a woman of Polish extraction and found special difficulty in narrating the precise nature of her feelings, her fears, her hopes, and her sufferings. But it is quite easy, I think, to perceive the order of events. It is abundantly clear that until the recovery of the body, she did not know that her child had drowned in the trench. Like most mothers placed in a similar situation, she was tortured between the fear that he had been drowned and the hope that either he was not in the trench at all, or that if he was, a quick recovery of his body and the immediate application of artificial respiration might still save him from death. In this agonised and distracted state of mind and body, she remained for about half an hour when the police arrived and the child's body was discovered and removed. During this crucial period, the plaintiff's condition of mind and nerve can be completely understood only by parents who have been placed in a similar agony of hope and fear, with hope gradually decreasing. In the present case, the half hour of waiting was the culmination of a long and almost frantic searching, which had already reduced her to a state of nerve exhaustion. Even after the finding of the body, an attempt at artificial respiration was made and abandoned only after expert lifesavers had worked on the child's body for some time. Few paragraphs have been so infused with the sense of a judge stepping down from the bench to commune with a suffering plaintiff. Evatt offers Golder Chester the voice she was denied by needing to speak in an unfamiliar tongue. He unites her with other mothers, perhaps even Evatt's own, in the experience of the agony of hope and fear occasioned by a child in peril. Twice Jeannie Evatt watched sons disappear into danger. Twice she endured the long wait for dreadful news that was always a possible outcome. Evatt's claim that it is not remarkable that there was evidence of some permanent injury to the plaintiff's nervous system almost certainly derives from personal experience. To universalise Golder's predicament, Evatt next did something even bolder, elaborating his point, as he was wont to in conversation, with literary citations from William Blake and Joseph Furphy. The latter is specially noteworthy, the innocent child lost in a harsh land being a ubiquitous Australian motif. Poets such as Henry Lawson, Banjo Paterson, Will Ogilvie and Barcroft Boak helped build the mythology, likewise artists as diverse as S.T. Gill, William Strutt and Frederick McCoven. These lost children of law had real-life counterparts. Furphy was one of hundreds who searched unsuccessfully for 3 boys lost near Daylesford in June 1867. and his 1903 masterpiece, Such is Life, is haunted by lost children. Early on, Furphy's alter ego, Tom Collins, falls in with a boundary rider and his wife, coming to regard their 5-year-old daughter Mary as the perfect young Australian and a child of the wilderness. But camping some months later, Collins hears of Mary's death from one of his companions, Thompson, who had taken part in the panic-stricken search. Longest night I ever passed, though it was one of the shortest in the year, eyes burning for want of sleep, and couldn't bear to lie down for a minute, wandering about for miles, listening, hearing something in the scrub, and finding it was only one of the other chaps or some sheep. Thunder and lightning on and off all night, even or 2 or 3 drops of rain towards morning. Once I heard the howl of a dingo, and I thought of the little girl lying worn out, half asleep and half fainting, and I made up my mind if she came out safe, I would lead a better life for the future. The denouement, with Mary being found dead in a bilby hole, starts a cycle of similar campfire yarns. Another storyteller, Saunders, tries lifting the gloom with a happier tale of a lost boy found in a hollow log. A last companion, Stevenson, narrates a grim tale of his childhood on the upper Campaspe, bad enough to lose a youngster for a day or two and find him alive and well, worse beyond comparison when he's found dead, but the most fearful thing of all is for a youngster to be lost in the bush and never found, alive or dead. The story concerns his own younger brother, who had wandered off after a quarrel between them never to be seen again. The consequences, Stephen explains, were fearful. Their father succumbed to drink, their mother took a lethal dose of laudanum, the family dissolved. Such remains his burden of guilt that he feels thankful to remember that every day brings me nearer to the end. It's a classic case study in long-term trauma. Australian jurisprudence contains no equivalent of Evatt's use of the aforementioned twin chunks of Furphy. Michael Meehan has called Evatt's the one brave instance of the quotation of an Australian writer and the integration of literature as local knowledge in an Australian legal judgment. Yet it was perfectly consistent with Evatt's patriotism that he should place an Australian novelist on par with an English romantic poet. The passages also provide an entry point on the incoherent area of the law. As Evatt says, not only its poets and novelists, but at any rate in recent years, those engaged in the administration of the common law of England have recognised that shock of the most grievous character can be sustained in circumstances analogous to those of the present case. The judgments he has in mind in particular are 2 by Lord Atkin, those in Donoghue versus Stevenson, the immortal snail in the bottle case, with its timeless duty of care question, who is my neighbour, and Hambrook versus Stokes brothers, which established the category of secondary victims who could recover for nervous injury. Evatt had been conducting a lively correspondence with the Anglo-Australian Atkin. He now set about using the tools Atkin offered for assailing the orthodoxies of his fellow judges. Jordan, for instance, had downplayed Golda's shocks on the grounds that she was in the capacity of a person looking for the body of a child then believed to be dead, rather than as a wayfarer startled by a distressing sight. And this, Evatt clearly thinks, is ridiculous. The stubbornness of hope which he has described tells us otherwise. It seems indisputable that the jury could have found that the onset of the plaintiff's nervous shock took place at a point of time when the plaintiff, although at the side of the trench, did not know or even believe that her child had been drowned. Equally, she was not looking for the body of a child, she was looking for her child. Golda was not looking for the body of a child, she was looking for her child. These are devastating lines. Evatt explains that Jordan has misread Atkin's use in Hambrook of the word wayfarer as placing shocked passers-by in a superior position to recover damages for seeing a horrifying sight than blood relatives. This makes no sense in the light of Atkin's neighbour test in Donoghue, which, as he observes, has rendered the law at once more civilised and more humane. Evatt clarifies further with some sociological observation. Let us apply this criterion to a reasonable person in the situation of the defendant counsel. Such a person would foresee that by leaving the trench inadequately guarded, it would probably become, especially when filled with water and provided with sand, a very attractive place to children in the neighbourhood of the trench. He would also foresee that, having regard to the unfortunate but notorious fact that children of work people are frequently compelled to play in the streets and also the fact that the water was in the trench, the special menace of the place would be that small children might fall in and be drowned. He would also foresee, when directing his mind to the dangers, that if a child got into the zone of the special danger, his parents and others would resort to the spot either to seek for the child, and that in doing so they might themselves sustain physical injury or illness caused by nervous shock and distress. The zone of special danger had been invented by the Wisconsin Supreme Court in 1935's Welb versus Warrington. A woman in frail health, Susie Welb, was looking out her window as her daughter Dolores was crossing the road and saw her killed by a careless driver, Amber Rose Warrington. The shock was so severe that Susie Welb died soon after. Her husband was denied damages, however, on the basis that his wife had been outside the area of physical danger. Evatt's retort is again to invoke universal understandings of the modern world and human behaviour. One cannot measure with mathematical precision the relative probability of the contingencies referred to, but I do not think it matters. With roads closely flanked by houses, there must always be a fair probability or possibility that if a small child is found on the road, his mother or father will be found in the vicinity keeping some sort of lookout on the child's movements. Evatt thereby groups Chester with a special category of negligence claims, search and rescue cases involving trauma to those rushing to assist the killed and maimed. This gave Evatt scope to invoke another legal hero, the American Benjamin Cardozo, in Wagner versus International Railway, involving cousins, one of whom was badly injured in the search for the other, who had fallen from the open platform of an overcrowded trolley car. It includes Cardozo's classic lines, "Danger invites rescue. The cry of distress is the summons to relief. The wrong that imperils life is wrong to the imperiled victim. It is wrong also to his rescuer." The duty owed to rescuers for physical injury, Evatt argues, should be extended to nervous shock. It should cover a mother attempting to find and aid her child, and not be precluded merely because of the fact that when she discovered the dead body some appreciable time after the accident, life was already extinct. If rescuers in accidents were owed a duty of care by the negligent, then surely family members, a highly foreseeable category of rescuers, were owed it too. Evatt lastly brushes aside Victorian Railways Commissioners versus Cultus from 1888, a 50-year-old decision in theory still binding on the Dominions, in which the Privy Council had disdained damages arising from mere sudden terror, unaccompanied by actual physical injury, but occasioning a nervous or mental shock, now clearly overtaken by the march of medical science. Evatt concludes, "It must always be a question of fact whether shock to the nerves causes actual physical injury. Today, it is known that it does. In 1888, it was widely assumed that it did not. It is on this basis that Cultus's case is to be understood, and if so understood, it has no application to cases like the present, where shock to the nerves is another name for actual physical disturbance of the nervous system." And so he concludes with a comment on his setting out his reasons at length because of the great importance of the present case, which is perhaps the only sentiment in the judgment it is unnecessary to state. You can read Evatt's judgment in Chester not only as dissenting a majority view in this case, but dissenting a majority view of judicial writing and legal thinking, casting only backwards and inwards. Law insisting that harm required lesions and lacerations ignored the march of science. Law incapable of acknowledging something so fundamental as maternal love was at odds with the humanity it purported to serve. Law had to take opportunities to innovate. This was only the second time such a case had come before the High Court, with no way of knowing when the next might come. In fact, it would be 31 years. After his travels the previous year, Evatt assuredly had an eye on the audience of legal scholars, which he duly attracted. Later that year, Law Quarterly Review gave Chester plush treatment in An Australian Shock Case, breezily disposing of the propositions of Latham, Rich and Stark, before proposing, Evatt J's dissenting judgment puts the contrary view in a powerful and eloquent manner, wrote Professor Arthur Goodhart. As this branch of the law is still unsettled, it would not be surprising to find that in the long run, Dr. Evatt's opinion will prevail. This prophecy would be fulfilled in Gench versus Coffey, 1984, where Justice Dean concluded it must now be accepted that the conclusion of Evatt J is on the facts in Chester plainly to be preferred to that of the majority. At the same time, the combination of his judgments in Corbin and Chester express Evatt's frustrations with the law's tendency to the status quo. Every day in 1939, the world inched a little closer to war, yet here he was, a comparatively young man, outnumbered by those who would never advance anything they did not absolutely have to. It can be read as a note to self that if Evatt wished for liberal and humane policies, he might need to play a part in their actual formulation. Lastly, are we left with Chester's personal resonances? Maxie was the same age as Evatt's daughter Rosalind, who had herself been unwell, and a similar age to himself on the death of his father. Thanks to their wartime tragedies, the shock of loss and the tragedy of unfulfilled promise still loomed large in his family. Evatt could hardly endorse a legal view that the sudden and distressing death of a child produced consequences of only a temporary nature, when he knew it so untrue in life. Deeply compassionate, unfailingly rigorous, Evatt's is, to my mind, the great Australian dissent. Thank you.
Thank you, Gideon. Associate Professor Kylie Burns from Griffith University is a leading tort scholar. Her research and teaching areas include torts, accident compensation systems, and judicial reasoning and cognition. She's the co-author of the leading Australian torts textbook, Torts, Cases and Commentary. If there was an academic version of Wisden's Almanac, Kylie would be described as a brilliant all-rounder. That includes her pastoral care for young law students, many of whom are the first in their family to attend a university, her prestigious teaching awards, her independent empirical research into compensation systems, and her learned articles. One of those articles, titled Judges, Common Sense and Judicial Cognition, starts, quote, "Judges are like other human beings," unquote. Some of us take that for granted, but Kylie thought it needed some support in a footnote that cited the writings of Professor Jerome Frank, a professor of psychology named Guthrie, and Justice Stephen Gagler, so it must be right. Please welcome Associate Professor Burns.
Thank you, Justice Applegarth, for that very generous introduction. Chief Justice, Judicial Officers, Fellows of the Australian Academy of Law, colleagues and friends present and online. We meet tonight in front of Indigenous artist Sally Gabori's magnificent artwork, which depicts family, place, and deep ancestral history. I acknowledge the traditional custodians of the land we meet on tonight and pay my deep respects to elders past, present, and emergent. I would also like to acknowledge my co-authors, Emeritus Professor Harold Luntz and Emeritus Professor David Hambley, both Fellows of the Academy, who I know are watching online tonight. Harold and David's work on the importance of the historical, human, and social context of tort law has inspired generations of tort law scholars, judges, lawyers, and law students. And I know that there'll be many present tonight who will be thrilled to know that Harold's long-awaited book on damages in its new edition is about to land. As I say to my students, every personal injury tort case is at its heart a tale of individual human suffering. Gideon's outstanding book intertwines the tale of Justice Herbert Evatt and Golda Chester and her lost child Maxie, and it starts with the story of human suffering. The book reminds us that recognising the suffering of those who are injured and the role of humanity in judging matters. The book highlights the fragility of common sense judicial reasoning, particularly when it conflicts with contemporary medical, scientific or empirical research. Chief Justice Latham's statement in the Chester case in 1939 that even the sudden and distressing death of a child does not produce any consequence of more than a temporary nature strikes us now as wildly ill-judged. Themes familiar to lawyers emerge in the book. Suspicion of personal injury claimants, fears of opening floodgates, the role of plaintiff lawyers in pursuing justice for the injured and making the world safer, the lag between law and science and medicine, battles between competing interests in personal injury law reform. For those familiar with the last few decades of tort law reform in Australia, it seems that all that is old is new again. The battles fought in the 1930s and 1940s have repeated over time with new combatants. Reading the book also highlighted for me, once again, how often the law then and even now fails to respond to the injuries and reflect the interests of women. Tonight, I will reflect on whether and how Australian law has progressed since the majority of the High Court refused to allow Golda Chester to recover in negligence against the Council of Waverley for nervous shock when her son, her brilliant boy Maxie, drowned in an unguarded trench of water. In the case and in the legal commentary, Golda Chester, a Jewish immigrant to Australia, is referred to as Janet Chester or Mrs. Chester. As Gideon notes in his book, her lawyer Abraham Lander, a well-known plaintiff personal injury lawyer and local politician, filed the case using the Christian name of Janet rather than Golda to avoid the anti-Semitic sentiment common at the time. Tonight, we recognise her humanity and her dignity as an individual woman who suffered greatly by calling her by her name, Golda. Australian tort law has moved on since 1939 and now recognises diagnosed psychiatric injury in some circumstances as foreseeable to defendants, such that a duty of care in negligence arises. But barriers and boundaries remain. Fears of excessive litigation and possible feigning of psychiatric injury simmer beneath the surface. Judicial decisions have been slow at times to respond to contemporary science and social science about the causes and prevention of psychological injury, and particularly reluctant in recent times to characterise workplace psychological injury as foreseeable to employees. All that is old is new again. After Golda Chester's loss, Abraham Lander fought to right a grave injustice, advocating for legislative reform. The battles in the New South Wales Parliament were fierce. Insults were thrown about unscrupulous lawyers forcing victims into litigation and floodgates opening. Justice Evatt worked behind the scenes, commissioning an academic report based on his own dissent in the Chester case, which was then forwarded to government. Finally, on the third attempt in 1944, 5 years after the Golda Chester lost her case, the generically named Law Reform Miscellaneous Provisions Act was passed. It was, as Gideon notes in the book, a notable moment in Australian history, allowing recovery for nervous shock by a parent or husband or wife of someone killed or injured, and recovery by other family members so long as they were within the sight or hearing of the death or injury. Only the ACT and the Northern Territory followed suit at the time with similar legislation. For parents and family members and others who suffered a loss in other Australian states, the law remained largely unresponsive to their suffering for decades more. It was all too late for Golda Chester, who died tragically by suicide in 1949, having never recovered from Maxie's death. 1966 was a dangerous year at the Mount Isa mine. By year end, 9 men had died in an array of terrible accidents. In April 1966, 2 electricians carrying out a test on a switchboard mishandled an instrument, causing a short circuit, resulting in an intense electric arc. The men were literally baked black, all their clothing except boots being burnt off. A fellow employee, Mr. Pusey, was working on the floor below. He heard the explosion and ran up a ladder into the switchboard room to find the gruesome sight and smell of one of the electricians just burnt up. Within days, both electricians had died. Mr. Pusey later developed what was then described as a, quote, schizophrenic reaction causing a chronic psychiatric disability. He brought an action against his employer in this court, the Supreme Court of Queensland. Mount Isa Mines relied on the majority judgment from Chester and Waverley to argue that Mount Isa Mines could not have foreseen an employee such as Mr. Pusey would suffer a rare psychiatric illness. Mr. Pusey was successful at trial and on appeal in Queensland and ultimately in the High Court in 1970. Justice Campbell in the Queensland appeal case referred to Chief Justice Latham's statement 30 years earlier that the sudden and distressing death of a child could not cause more than a temporary harm, and noted, perhaps in an understated way, many informed people these days may well take a contrary view. The High Court held that as a prudent employer, Mount Isa Mines should have reasonably foreseen that a fellow employee coming across such a distressing scene could suffer a psychiatric injury, thus giving rise to liability. In 1984, the High Court moved Australian common law forward in Yance and Coffey, a case concerning the aftermath of an accident in Adelaide in 1979. A car hit and seriously injured Alan Coffey, a traffic policeman on a motorcycle. His wife Vicky was taken to hospital where she saw her husband in severe pain and in intensive care. She was advised it was possible that Alan would not survive. While Alan did survive, Vicky developed a severe psychiatric illness within a week of the accident. Vicky had lived a very traumatic life prior to her marriage. She had been subject to severe sexual abuse as a child and had a difficult relationship with her family. She left home at 15. She had a relationship with a serviceman who was killed in the Vietnam War and had a child. That child was ultimately adopted. The loss of her child through adoption caused her deep grief from which she never completely overcame. Her mother died shortly before her marriage. Her relationship with her husband Alan was perhaps her first secure, loving relationship. At the time of the accident, she was the new mother of a baby daughter. She was happy, although perhaps more vulnerable to psychiatric or psychological illness as a result of her life trauma, and that she was only several months post-birth. At trial and appeal in South Australia and in the High Court, Vicky Coffey's psychiatric injury was found to be foreseeable and to have occurred in the aftermath of the accident, and she was awarded damages. Both the South Australian courts and the High Court rejected the majority decision in Chester and Waverley, preferring Justice Evatt's dissenting judgment. Justice Dean said, "The judgments of the majority in Chester's case have not worn well with time. The proposition upon which those judgments based is no longer, if it ever was, acceptable. It is simply out of accord with medical knowledge and human experience to deny that it is reasonably foreseeable that the shock suffered by a mother on seeing the body of her infant child, with whom she was seeking, raised from the bottom of a water-filled trench might well be such as to cause psychoneurosis or mental illness." Despite the decision in Vicky Coffey's case, over the next 2 decades, Australian negligence law regarding psychiatric injury became increasingly murky. State courts in Australia reflected developments in English law, erecting further barriers to recovery for plaintiffs, driven, again, by the fears of the consequences of expanding liability and opening the floodgates. In 1992, the House of Lords decided a case involving 10 people who had lost relatives and loved ones at the Hillsborough Stadium disaster. During the 1989 semi-final of the FA Cup between Liverpool and Nottingham Forest, 96 men, women and children aged between 10 and 67 were killed and many hundreds more were injured. Police had allowed too many people to enter the ground, resulting in a massive crush in a fenced standing area. Multiple inquiries and inquests were held over the next 30 years, ultimately culminating in government apologies and, most recently in the last several years, unsuccessful prosecutions of police officers and others. The repercussions of this tragedy reverberate to this day, and the families still fight for justice. The 10 plaintiffs in the House of Lords included brothers, sisters, grandparents, a fiancé, and parents of the dead. Some witnessed the scenes live on television. Others later saw footage. All heard of the deaths within varying timeframes. Some went to the mortuary and identified the bodies of their loved ones. The House of Lords identified policy-based bright lines which all needed to be satisfied for a plaintiff to be successful. These included the need for a close, loving relationship with the injured or deceased, a sudden shocking event, proximity in time and space to the accident or its immediate aftermath, and the suffering of a shock through your own sight or hearing of the event or aftermath. It's important to note that these requirements were arbitrary and did not necessarily, if at all, reflect the science regarding causation of psychiatric injury. None of the 10 family members were held by the House of Lords to sufficiently satisfy all of those requirements. For example, 2 parents, Mr. and Mrs. Kopak, lost a son. They saw the disaster unfold on television, and Mr. Kopak identified the body the following day. This was not close enough. The application of these bright lines in the United Kingdom have continued to cause injustice. In the last month, the actor Jamie King has lost an English High Court case arising from the post-traumatic stress disorder he suffered following the death of his 5-day-old son Oliver after a negligently delayed birth. Mr. King visited the neonatal intensive care unit following the birth and saw his son covered in tubes and wires and was told he was very ill and might die. While suggesting this might have been horrifying, the court held it was not a sudden and unexpected shock as required by the Hillsborough case. Sometime very early in December 1986, 2 teenage trainee jackaroos, James Annetts, 16, and Simon Amos, 17, went missing on an outback station deep in the Kimberley in Western Australia. James's parents, Sandra and Les, had contacted the managers of the station prior to sending James from his home in New South Wales on what was to be a great adventure. They were assured that he would be looked after and supervised. Instead, after a short period of time, James and Simon were sent as caretakers to a separate remote outstations in the Great Sandy Desert. They were each alone in primitive housing, and working conditions were harsh and abusive. On 6 December 1986, the police telephoned James's parents in New South Wales and advised them James was missing. Sandra and Les travelled to Western Australia numerous times, trying to find out what had happened to their son. In April 1987, 5 months after they went missing, the bodies of James and Simon were found in the desert, some distance from a broken-down vehicle. Sandra and Les were notified by telephone at home in New South Wales, and Les later identified the skeletal and ravaged remains of his son by looking at a photo in the Halls Creek police station. A controversial coronial inquiry later found Simon had died of a gunshot to the head and James had perished of dehydration and hypothermia. Why they left the outstations and the circumstances in which they died remain a mystery to this day. There was extensive media coverage of the events, including an episode of the ABC program Four Corners, and several books have been published. Broader questions were raised about poor working conditions on outback stations in Western Australia. Sandra and Les suffered psychiatric injury following the death of their son. They fought for many years to seek justice for James through the lengthy coronial inquiry process and then ultimately through their own action in negligence. Before their negligence case could be fully heard on the facts, the Western Australian Supreme Court and Court of Appeal considered as an initial issue whether it was even possible in law for a duty of care to them to arise. In the Western Australian Court of Appeal, Justice Ip, who later chaired the 2002 review into the law of negligence, gave the leading judgment holding a duty of care could not be shown. The appeal court relied on the majority judgment in Chester and Waverley, the House of Lords Hillsborough decision and other cases to find it was not foreseeable that ordinary parents of normal fortitude would suffer psychiatric injury at the loss of their son. The loss was not resultant on a sudden sensory perception of a distressing phenomena, and the parents did not directly perceive the relevant events in the relevant geographic area. After he had been missing in the desert for many months, they must have known their son was dead. They were far away from him when he died, alone in the desert, and when they heard the news of his death. 16 years after James died, the High Court heard the Annetts appeal from the decisions to deny them a chance to bring their action in negligence. But it was not the first time the Annetts had been to the High Court. They were parents of exceptional fortitude. Several years before, they had had to argue, ultimately successfully, all the way to the High Court for a direction that their own counsel be allowed to make closing submissions at the coronial inquiry into James's death. At the time of the hearing of their High Court appeal in the negligence case, Sandra told the ABC in an interview, "When you're fighting multimillionaires, right, what hope do people like us have? We don't have a hope in hell. And they're all so proud of their kids, right, that have achieved this and achieved that. Well, I can assure those people, I was every bit as proud of James as what they are of their sons. And he worked hard for that little lousy bit of money he got each week, right? And his life was taken, and no one over there is going to do anything about it. James had been her brilliant boy." The High Court allowed the Annetts appeal, holding it was clearly foreseeable as parents that they could suffer recognised psychiatric injury as a result of James's death, particularly given the assurances that had been given to them by the employers. As in Yance and Coffey, Justice Evatt's dissent in Chester and Waverley was preferred. The High Court fundamentally diverged in direction from English law, holding that the additional elements required in the Hillsborough case, such as sudden shock, direct perception and presence at the accident or aftermath, were not required to be demonstrated in every case in Australian law to found a duty of care. The key question was one of foreseeability. Not all psychiatric injuries, though, were held to be foreseeable by defendants. In the companion case, Tame and New South Wales, decided quite unusually with the Annetts case, the High Court held that psychiatric injury arising from a clerical error in police investigative records about the plaintiff's blood alcohol level, which were later corrected, was not foreseeable. After the High Court case in 2003, almost 2 decades after James died in the desert, Sandra and Les Annetts reached a confidential settlement with Heytesbury Holdings, a company owned by the Holmes à Court family who had purchased Australian stations. They were said by their lawyer to be relieved but exhausted. As Professor Barbara McDonnell has suggested in her article about Justice Evatt's dissent in the Chester case, unfortunately, the story of Evatt J's dissent in Chester does not end with the common sense, logic and humanity shown by the High Court in allowing the Annetts claim, a result of which he surely would have approved. The Annetts case was decided in the early 2000s, at the height of a period of Australian tort reform. During 2002 to 2003, Australian state and territory governments, fearing floods of unmeritorious claims, passed tort reform civil liability legislation. In some jurisdictions, this included provisions limiting recovery in negligence for psychiatric injury. Such fears were, as it turns out, in retrospect, not supported by empirical evidence of increasing litigation. The resulting reform legislation tended to reinstate, and in some jurisdictions, many of the arbitrary requirements adopted by the UK courts. Perhaps the best example of the injustice this legislation has led to is King and Philcox, which concerned the South Australian civil liability legislation. Ryan Philcox suffered a psychiatric injury following the death of his brother Scott in a car accident. Ryan had driven through the intersection, the scene of the accident, multiple times in the hours following the accident and had seen sights such as damaged vehicles and emergency vehicles. He was not informed until later that night his brother had died in the accident, and he suffered immense anguish that he had passed the scene and had not helped his brother. The legislation provided that he could only be awarded damage as a sibling if he was present at the scene of the accident. The High Court held Ryan was not at the scene of the accident and therefore could not recover. The legislation would, however, have allowed recovery by Scott's parents, spouse or child, as they did not face the additional hurdle of showing presence at the scene. Unlike some other states, I would say wisely, Queensland did not legislate additional hurdles to recovery of damages in negligence for psychiatric injury. To the best of my knowledge, we have not in this state suffered a flood of unmeritorious psychiatric injury claims as a result in the last 20 years. It seems that, unsurprisingly, the need for a plaintiff to be diagnosed with a recognised psychiatric injury, to overcome all legal, practical and financial barriers to bringing action, and the extremely stressful and lengthy process ensuing in negligence has been disincentive enough. There are also large-scale examples in Australian history in recent times of psychological injury suffered by First Peoples victims of the stolen generation and victims of institutional child sex abuse, where there have also often been insurmountable barriers to recovery. Several years before the High Court heard Golder-Chester's case, it heard the case of Bunyan and Jordan. Lucy Bunyan was, like Golder-Chester after her, represented by Abraham Lander and Justice Evatt's brother, Clive Evatt, KC. One evening during late-night trading, Lucy, a shop assistant, came across her employer, Arthur Jordan, highly intoxicated with a gun and a bottle of poison in the back office. She overheard him say he was going to shoot someone. Later, she heard a firearm discharging. Unsurprisingly, she felt highly nervous and afraid, but worked until the end of her shift and took the shop takings to her employer. He then tore up some of the banknotes and said, quote, she would hear of a death before the morning. A doctor had to come and give him some powders, presumably a sedative. The employer advised the police that he had fired a weapon, but that he had some armour underneath his clothes, and he did it, quote, with the idea of putting it up the boys, apparently his sons. With modern eyes, we would likely see this as outrageous and unlawful conduct by an employer, and clearly a very unsafe workplace. Lucy ultimately lost her job when she could not return to work. In 1937, the majority of the High Court refused to allow recovery. They held it was clearly not foreseeable that Lucy Bunyan would develop a psychiatric injury as a result of the conduct. Again, Chief Justice Latham. In the case of ordinary persons, if a man said to them that he was going to shoot somebody and they then heard a shot, or even if they saw the speaker shoot himself or someone else, they would be disturbed or perhaps upset in varying degrees, but they would not suffer from illness producing a nervous breakdown. Other judges in the High Court said the employer's only purpose was sensationalism. Any harm in a normal person would only be transient. There could not be any foreseeability of a plaintiff who is delicately constituted. Justice Rich, or perhaps Dixon, cast aspersions on Lucy's motives as perhaps related to her loss of employment. He suggested that a reasonable person would not be affected in the circumstances, but perhaps a female clerk could not be expected to fully appreciate the theatrical threats of the employer. Justice Evatt dissented. We might think courts think differently today about the foreseeability of psychiatric harm to employees in their workplaces. In the Mount Isa Mines case I discussed earlier, the High Court was receptive to a claim by a psychiatrically injured employee who went to the aid of a catastrophically injured workmate. It might be thought that the well-recognised duty of care owed by employers to employees to take reasonable care for their safety extends to both physical and psychiatric harm. This is certainly the case in workplace health and safety statutory duties of employers, which clearly extend to both risks, physical and psychiatric. There has been recognition internationally and in Australia for decades, including in extensive research and by government workplace health and safety organisations, that workplace psychosocial hazards increase the risk of workplace stress and, if prolonged, can lead to physical or psychological injury. Safe Work Australia notes the common workplace psychosocial hazards include long work hours, high workload, high job demands, working in a hazardous or high-pressure environment, working with distressed or aggressive clients, exposure to violence and trauma, poor support in the workplace, workplace bullying or harassment, and sexual assault. Psychological injury in the workplace costs the Australian economy billions and billions of dollars each year. More time on average is lost from stress injuries than physical injuries, making the claims expensive. Psychiatric injuries in the workplace are disproportionately suffered by women. Most psychiatric injuries caused by workplace sexual harassment and sexual assault are suffered by women. It is infuriating that we have seen in recent times that women are at risk of psychological injuries from sexual harassment and sexual assault in workplaces where they should be the safest, the highest courts and federal parliament. The 2020 Productivity Commission report on mental health, the Respect at Work, Sexual Harassment National Inquiry and other inquiries have called for changes to take the risk of psychological injury in the workplace seriously and to take steps to prevent and compensate psychological injuries to workers. There are some steps forward. For example, changes to workers' compensation legislation in Queensland to presumptively recognise injuries suffered by first responders. New enforceable workplace health and safety codes of practice on prevention of psychological injury. Workplace health and safety investigations of employers, such as law firms, for requiring employees to work excessive hours, and national employment standards in fair work legislation that it is unlawful to require Australian employees to work in excess of 38 hours per week unless the hours are not unreasonable. But recovery for workplace psychiatric injury in negligence in Australia remains difficult. In 2005, Nuala Kohler was unsuccessful in an action against her employer for psychiatric injury which she suffered following excessive workload. The High Court placed additional boundaries of the scope or content of the duty of care for workplace psychiatric injuries. The court held an employer may not be liable for psychiatric injury brought about by the employee's performance of the duties originally stipulated in their contract of employment. In addition, the court refused to recognise that psychiatric illness from work-related stress is foreseeable for all employees. The common sense assumption underlying the decision was that individual factors relevant to individual employees are the primary factor in foreseeability of workplace psychiatric injury. In the absence of evident signs from the employee of the possibility of psychiatric injury to them, an employer is entitled to assume they are not at risk of psychiatric injury. While there have been some successful workplace psychiatric injury cases since Kohler, it has been difficult for plaintiffs to overcome these barriers. More barriers have been added in later cases. For example, that a duty does not extend to making inquiries of employees who may appear to be suffering on the basis that, as a matter of common sense, employees may think this breaches their privacy. This conflicts with recognised good workplace health and safety practices, which suggest that early intervention by employers in the identification and treatment of workplace psychiatric injury is essential. It also does not reflect, I would say, where we have come to in our society in relation to acknowledging and normalising suffering from mental illness and supporting those who suffer. I consider that Australian law about workplace psychological injury and negligence has taken an unfortunate turn since the Kohler case. There has been a failure to recognise a proactive duty owed by all employers to all employees to attend to relevant psychosocial hazards in the workplace which only the employer can control. Reactive duties of care are only generally recognised down the track when an employee begins to exhibit signs. Often this is just much, much too late. The judicial common sense approach about the foreseeability of workplace psychiatric injury has at times sharply diverged from empirical evidence and has not been coherent with workplace health and safety policy and legislation and industrial legislation. All that is old is new again. The High Court will soon hear the first psychiatric injury negligence case it has heard in quite some time, in Kozarov and State of Victoria. This is a contemporary lost child case. Zagi Kozarov, a public prosecutor and single parent of young children with a crushing workload in a child sexual abuse unit, suffered vicarious trauma. She developed post-traumatic stress disorder as a result of horrific exposure to the suffering of children, including repeated exposure to graphic images and videos of assaults and rapes of children, dealing with the distress of child complainants, and dealing with the aftermath of failed prosecutions, including complainants who attempted suicide. Her experience mirrors that of many lawyers and judicial officers who day in and day out witness and experience highly distressing things in their workplace. Will Zagi Kazarov's case repeat that of Goldchester? Only history will tell.
Have you traced any of the cases that you talked about to look at the long-term consequences of people who the law glimpsed for a second and then that moved out of sight?
I think one of the most interesting cases that I looked at in preparation for this, sort of following your example, was the Annette's case, because the interesting thing about the Annette's case is that when it was initially argued in the courts, it was argued with what we call assumed facts, and that is it was never fully tried with evidence because the courts were really just concerned about determining a legal principle. So there were a very short number of agreed facts, and that was the story that I'd always told when I taught the case. I certainly wasn't aware that there'd been such a lengthy process, that it was highly controversial. The Annette's parents, I don't think, ever accepted the coronial inquest. They didn't think that the death was accidental. Certainly some of the press coverage at the time suggested that they thought more nefarious things had occurred, that there might have been criminal intervention. I mean, what actually happened that day never became known. It's certainly clear that they battled on such a long time. To think that it was almost 20 years before the case actually resolved itself. But also, I was never aware that they had had two cases to the High Court. To think that they had to fight twice and fight the first time all the way to the High Court so that they could have their own counsel give finalising submissions at the coronial inquest. I thought that was just an amazing part of the story. One thing I say to students when I'm teaching these cases is what we're talking about is the worst thing that happens in people's lives. We tend to tell the stories, we'll give like the briefest snapshot of facts because we're not that interested in the facts, but it's really the story of suffering that matters, and that's what we really actually think about when we do compensation system research. We start to think about, okay, what kind of system best responds to the fact that someone suffers and their family suffers for the entirety of their lifetime. The other thing is the Janssen Coffey case. Certainly I gave a little snapshot of the other things that happened to her. That's always, when I'd heard that spoken about before, usually says something like, she had experienced a traumatic life. Well, if you go back to the trial decision and the appeal decision, which I'd certainly never read before now, it was an enormous life of trauma. And it also struck me when I was looking at it, she had a 3-month-old baby at the time this happened. So, probably even thinking around postnatal depression and those sorts of things and what might trigger that was never looked at. So, I think I'm glad for your work, and I think it's a real gap that we don't know, and we don't follow the full story of what happens to people.
I might say that as well as being an important legal story, my book is a work of Australian history. It's a work of Australian history where the law intersects with day-to-day events, but it required the use of traditional kind of historical tools, including primary source documents and archival materials. Some of you might know that I've recently been involved in a campaign to provide emergency funding for our embattled National Archives, and the Brilliant Boy relies heavily on the records of the High Court that the National Archives has been good enough to maintain. I went to Canberra to sit in the reading room to go through the appeals books and the letters books of the High Court during the 1930s. These are absolutely invaluable resources that we sometimes neglect, or maybe we take for granted they're always going to be around. It actually takes an active preservation and foresight by people who are involved in this area to ensure that these records are available to us. That's why, as you can see on my T-shirt tonight, some of you might have seen in the background, I'm a member of the Archives Liberation Front, who are vigilant in our protection of Australia's primary documents. I just thought I'd bring that to your attention. It's a constant battle to look after those things that we take for granted, but that we don't know when they're going to be useful. Some down the track, someone is going to want these things. It just so happened that in this case, it was me looking for the records of the High Court in the 1930s, and actually disinterring the Corbin judgment, which I referred to earlier, which is an unreported judgment. It's not on any other legal database. I came across it when I was going through Owen Dixon's diaries, and he referred to a case. He actually misspelled the name. He spelled it Corbin, and I thought, I've never heard of that case, and I can't actually find it on Ausli. And I got in touch with the High Court, and they said, oh, it's this particular case, it's unreported, but you might be able to find it in the National Archives. And it actually turns out to be this fascinating sort of phantom twin of Chester's case that anticipates many of Evatt's concerns, has a similar kind of repertoire of legal precedents, and expresses in a lot of ways Evatt's own abiding frustrations with the status quo in law, which he finds an outlet for in Chester. So can I just say that protect your local archive. It's important. It's important not just for you, but for generations hence.
There was one thing I particularly wanted to comment on because it was important to me when I was researching, and it was really following some of the material that came out in the book, and that was to name people and to use their names. Certainly in feminist tort theory and feminist analysis of judgments, we've often talked about the fact that women are not named, that they're often, so Mrs. Chester is referred to as Mrs. Chester as opposed to her name, and I actually found it deeply sad that when the case ran, she was called Janet. In fact, their surname also wasn't Chester. They'd anglicised their name when they came to Australia. So I think finding and calling people by their names, and I think there's a lot of sharing of judgments now, and I'm noticing it particularly coming out of the UK and others, where people's names are used, or sometimes obviously it's not their real name, they're given a name. It humanises the story and the suffering. So I think one approach to writing feminist judgments is often tell people's story first and use their names. And I research the names of the Annettes because I think it's important. It's about people's suffering and that their story be told with their name.
It's actually one of the first things that we say in our courses with the judicial colleges, which Peter was a part of, because as journalists, as writers, we find the language of applicant and respondent and plaintiff and defendant a little bit alienating and confusing too. A judge knows because they've sat in on the case who all these people are, but the reader doesn't. The reader has no idea. And often it's like getting a face full of mace when you read a legal judgment. It's all so terribly confusing and topsy-turvy. Interesting. I would say that I think that Evatt's is a very well-written judgment. I think it's a very lucid judgment. I think it's a very accessible judgment, even though the concepts that Evatt is using seem to be esoteric. He always finds a way to drag it back to a sort of a commonplace exposition, even for someone like me who hadn't done torts and who's never darkened the door of a university, had no particular difficulty in understanding it. And when I didn't understand it, I just rang up Mark Lunny from the University of New England, who's an outstanding legal scholar, and who I think he's out there tonight watching us, and I'd like to pay tribute to Mark as my tort whisperer.
We might proceed to the conclusion of the proceedings tonight. It gives me great pleasure to invite the Chief Justice of Queensland, the Honourable Catherine Holmes, AC, to move the vote of thanks and to close the proceedings.
I'll start the vote of thanks with a small confession, which is that when my son, who was in first year law, asked me to look at an assignment for him, I said, just chuck out all that stuff about the dissenting judgment. Nobody cares about the dissenting judgment. That approach was wrong, because as we know, a dissenting judgment may ultimately prevail, as Evatt's did in Chester. It was also wrong because my son got marked down and he's never let me live it down. And it was wrong because I actually do think that some dissenting judges matter very much indeed. I've always been a big fan of Lord Atkins in Liversedge and Anderson. And Evatt's judgment in Chester is another such, of which we have heard this illuminating analysis by, I think I'd better call him Gideon Haigh. I was going to say Mr. Haigh, but it may not be sufficiently personal enough. I'm not sure. But having mentioned Lord Atkin, one of the reasons this lecture has been particularly fascinating is the context that it gives. It's not just the judgment, it's the background. I had no idea that Evatt had any relationship with Lord Atkin, let alone that they were correspondents pen-paling about Donoghue and Stevenson. And we got from Gideon that personal background of Evatt's, about which I knew nothing too, the loss of the 4 brothers and the grief that he must have seen his mother go through, and also probably his identification with Maxie Chester as his mother's pride and joy and great hope. We like to pretend that judges operate in a sort of silo of objectivity, but of course we don't. And that's why lectures like this, why what Gideon Haigh has done is so illuminating, filling in that background to a judgment that you don't get as lawyers. And then to add that, we've had Kylie Burns' explanation of the legal context where Evatt's approach to psychiatric injury fits in the tapestry of common law and legislation. I think she's made it pretty clear that she does not think this has been a linear sort of progress. But she too blends the human and the legal in an extraordinarily sympathetic and listenable way. They've both been riveting talks. We've been very lucky to hear them, and we've been extraordinarily lucky to be able to hear them in person. So let's thank them for those talks.